Hi, I'm Dr. Alison McInnes from the University of Northumbria in England. Within the context of social work in England, I've been asked to give my opinion on the relationship of social work to the Human Rights Act and the possible rejection of the European Convention on Human Rights, and finally my experiences of carrying out collaborative work as a social work educator in Tajikistan. Firstly, a background to a British model for human rights. The European Convention on Human Rights was drafted largely by British lawyers on the thrust of Winston Churchill to prevent a repetition of the atrocities of World War II. Contemporary human rights were first recognised internationally by the Universal Declaration on Human Rights, 1948. This was quickly followed by the adoption 2 years later of the European Convention on Human Rights. The UK was the first country to ratify the Convention in 1951. The Human Rights Act is a UK law passed in 1998. This law makes the human rights in the European Convention on Human Rights directly enforceable in the UK. It means that an individual can defend their rights in the UK courts and that public organisations, including social services departments, must treat everyone equally with fairness, dignity and respect, no matter what their circumstances. This important provision has arguably improved the delivery of services by public authorities, including social services departments, and increased transparency and accountability of their policies and practices. The Human Rights Act protects all members of society, young and old, rich and poor, healthy and unhealthy. One hopes one will never need to rely on this law, but every year hundreds of people do. Despite this, the Act is frequently misunderstood and misrepresented. Likewise, the College of Social Work in England reflects the following values enshrined in human rights: respect by inspiring respect for the profession of social work, dignity by working to promote the dignity of people who use social work services, and social justice as a voice to work to promote inclusion. Who can use the Human Rights Act? The Human Rights Act may be used by every resident in England or Wales, regardless of whether or not they are a British citizen or a foreign national, a child or an adult, at liberty or in prison. What does a Human Rights Act actually do? As mentioned earlier, the human rights that are contained within this law are based on the articles of the European Convention on Human Rights. The Act gives further effect to rights and freedoms guaranteed under the European Convention. What rights does the Human Rights Act protect? So in Article 1, the right to life. It protects your life by law. The state is required to investigate suspicious deaths and deaths in custody. Second article, the prohibition of torture and inhumane treatment. In England and Wales, nobody should ever be tortured or treated in an inhumane or degrading way, no matter what the situation. Protection against slavery and forced labour. Fourthly, the right to liberty and freedom. You have the right to be free, and the state can only imprison you with good reason, for example, if you're convicted of a crime. The right to a fair trial and no punishment without law. In England and Wales, you're innocent until proven guilty. If accused of a crime, you have the right to hear the evidence against you in a court of law. Sixthly, respect for privacy and family life and the right to marry. This is an important article. This protects you against unnecessary surveillance or intrusion into your life. You have the right to marry and raise a family. This article is especially important to social work practice. Seventh article is freedom of thought, religion and belief. You can believe what you like and practice your own religion and all beliefs. Article 8, free speech and peaceful protest. You have a right to speak freely and join with others peacefully to express your views. Ninth article, no discrimination. Everyone's rights are equal. You shouldn't be treated unfairly because of your gender, race, sexuality, religion or age. And finally, Article 10, protection of property, the right to an education and the right to free elections. This protects against state interference with your possessions. It means that no child can be denied an education, and that in England and Wales, elections must be free and fair. What does this mean for social work? If a service user can show that a public authority, including social services, has interfered with any of the rights recognised by the Convention, you can take action in a number of different ways. For example, you could write to the Social Services Department and remind them of their legal obligations under the Human Rights Act and ask them to rectify the situation. You can go to court, which may find that a particular action or inaction of the Social Services Department is or would be unlawful. The court can tell a public authority, including social services departments, to stop interfering with your right or take action to protect your right. If a court is satisfied a provision of a law is incompatible with a convention right, it may make a declaration of that incompatibility. The Human Rights Act 1998 provides a unique model for incorporating the convention, which is in keeping with British constitutional traditions and the doctrine of parliamentary sovereignty. However, Britain's legal recognition of human rights did not begin with the Human Rights Act. Our human rights laws date back to the Magna Carta of 1215 and the Bill of Rights of 1689. Parliamentary sovereignty. The sovereignty of Parliament in England and Wales is the key principle of the British Constitution. This means that Parliament can alter any law and no judicial authority has a right to overrule its legislation. The Human Rights Act adheres to this concept of parliamentary sovereignty, as it is not possible for British courts to declare void any legislation where it breaches the Human Rights Act. Instead, courts can make a declaration of incompatibility, and Parliament may decide what action to take regarding this declaration. Taking into account decisions by the European Court of Human Rights. When a British court or tribunal is interpreting domestic law, which is relevant to the European Convention on Human Rights, the court or tribunal must look at how the European Court of Human Rights has interpreted this right. This helps to ensure consistency. However, the Human Rights Act makes it clear that these judgments are not binding on British courts. In fact, there have been 4 cases since 2000 in which the British courts have declined to follow judgments of the European Court of Human Rights. Adopting the Convention to the needs of Britain. The Human Rights Act is essential for the protection of human rights in the UK and is well crafted to balance Britain's international obligations with our constitutional conventions. In particular, it maintains parliamentary sovereignty and a primary role for judges in the interpretation of the Convention. The relationship between social work and human rights. In my opinion, together, the Human Rights Act and Western societies have created a state role for social workers to carry out protective and intervening functions in relation to children and other vulnerable groups. Social workers need to safeguard, protect, defend, give a voice to and advocate on behalf of the poor, marginalised, deprived, vulnerable and defenceless in society. Indeed, the Human Rights Act 1998 places a duty on public agencies, including social service departments, to intervene to protect the rights of children and adults and enable them to live lives free of violence and abuse. It is therefore a benchmark for good social work practice. However, Boycott in 2013 reported that unfortunately the Justice Secretary in England envisages abandoning the European Convention on Human Rights in British legislation. The Home Secretary appears to go further and proposes pulling out of both the Convention and the European Court. In sustained In a sustained broadside, Lord Sumption, a UK Supreme Court Justice, raised fundamental questions about the court. He highlighted one example of the court's creative role in reinterpreting the Convention to take into account contemporary circumstances, namely its interpretation of Article 8 of the Convention, the right to private and family life. Lord Sumption's forthright comments reinforce a speech by Lord Justice Laws, the longest-serving member of the Appeal Court, urging judges to stop deferring to Strasbourg on every issue. Taken together, they present evidence of growing judicial resentment of the absolute authority of the court. I would argue if we abandon the European Convention on Human Rights in British legislation, that this is a frightening prospect for social work in England and contravenes its basic values of safeguarding and protecting the most vulnerable people in our society. Next, I'd like to talk to you about my personal experiences of international social work as an educator, a social work educator. I spent much of 2008 in Tajikistan setting up a social work degree at a university there. Gray, 1995, identifies social work's altruistic mission of helping others and responding to human needs and the pursuit of social justice as universal values. So I was asked to do this work responding to a human need in Tajikistan. Therefore, concern for equality must extend worldwide, and this should be reflected in the ethical obligations of social workers practising worldwide, according to Healy, 2008. However, it's self-evident that Western social work knowledge, standards and definitions are not universal. Indeed, how can we ever be culturally neutral or locate ourselves objectively? What is needed instead is authentic knowledge and definitions based and developed on local standards. So I can't go in there and say what needs to be done. We need to look at local standards. Lavalette and Ikomedes in 2011 argue that rather than internationalisation of social work, we should look instead to social work internationalism. This means learning from projects, philosophies and perspectives about what social work is and the activities it encapsulates from around the globe. Internationalising social work education creates a Western hegemony in disseminating knowledge, according to Payne and Askland, 2008. This is perhaps an argument that universal social work definitions and knowledge assume uncritically that such knowledge may be transferred from Western societies and applied to other societies with markedly different cultures and access to resources. I would argue, from my experiences, therefore, that there is a need to develop social work definitions and standards nationally by raising the awareness of those charged with the responsibility to educate social workers locally. From personal experiences, I've found that the universal definitions and standards of the West cannot be deployed to other countries in their entirety and should not be seen as a gold standard. Indeed, it can be argued that if the social work profession of the West is in crisis, with staff shortages, financial constraints and poor morale, then it is hardly the perfect exemplar. Some of these issues were exemplified by the death of baby Peter in England and the subsequent high-profile inquiry which was published whilst I was working in Tajikistan. There is strong evidence that the failures of individual and interagency working, which failed to prevent Peter's appalling treatment by his mother and her partner, are not typical of social work practice or experience in the West. However, in the short term, arguably this perception may have impacted negatively on the profile of Western social work internationally. So in conclusion, my chapter is engaged with the history and development of social work in England, identifying the main strands that have contributed to contemporary policy and practice. It is argued that social workers in England need to be enabled to use all available approaches to advance the human rights of the diverse individuals we work with. Overall, I've argued that the relationship between the social worker and the state in England today is corrosive. The state is effectively employing strategies like benefit cuts that are inherently harmful to the population of vulnerable people that social workers engage with. It can be argued that the poor and those living on the edge of society are being targeted by the current government. It may be the time for social workers in England to release the potentials for community and radical social work that has long been neglected. As social workers, we need to work in unity to resist the attacks on social work and social welfare in the UK, and internationally step away from the edge. Well, I hope you found that interesting. Thank you very much for your time today, and goodbye. Thank you.